Eleanor Fox, Ted Lipsky. Welcome to Competition Exchange, a series which Or Brook and myself are doing within the Digital Markets Research Hub, aiming to invite two leading voices in antitrust community represent or known to represent different, if not antagonistic positions, for an amicable but tough exchange of ideas. And we are very grateful to both of you for finding the opportunity to engage in this format. Let me pass the floor to Or introducing the topic because there is no need to introduce the panelists.
Thank you very much, and thank you so much for taking the time and speaking with us today. Today we're going to want to talk about maybe obvious questions about competition law that we often discuss about the goals of competition law, about the enforcement structure, but try to hear two quite different opinions. For the first question we thought of, let's start with one of the biggest questions of all times of competition law, about what the goals of competition law should be. Eleanor, do you want to start?
Thank you. Thank you for inviting us, and a pleasure to be here. So I was expecting you to say what the goals are rather than what they should be, because I think that goals of competition law should have some flexibility to vary according to the jurisdiction. So I wouldn't say that there is one mode that competition laws should be, except in a very general way. Competition laws should be about preserving competition and preserving competition for all the stakeholders, the consumers, the suppliers, everyone in the chain, in the market chain. It should not be for protecting any one of those stakeholders in the chain, but it should be making the market work. And I think that is conceptually on a high level. I think that is the goal of virtually everybody's competition law. And the question is whether they add a couple of things.
And okay, so a few questions based on this statement. I think the first question is, what should we do when protecting competition means different things for different players? So when we have different players in the supply chain and competition means something different, or when we have protecting the process for innovation versus consumers in the short term, how do you think that should play out?
It all depends on what the particular problem is. So if the particular problem is a traditional problem where the harm is to the consumers, it's not a problem. So you would be raising the problem when it's not the traditional problem. It might be suppliers who are subject to monopsony power, as in a couple of mergers that were prohibited in the United States because of the creation of monopsony power. It's usually either monopoly or oligopoly power or monopsony or oligopsony power. And I don't think it's very difficult for it to play out. You could raise questions, for example, if there is a market monopsony harm to suppliers, should you still also look at consumers and what is the effect on consumers? So if there is a buying cartel, like under one of the old US cases, which found an illegality in a sugar case, the suppliers got together and to squeeze the suppliers. That was illegal per se. And you don't look to see what the effect is on consumers. It's possible that the monopsonists could have simply taken the profits for themselves. It is conceivable they could have passed it on to consumers. That's where the issue comes in. And if it's not a per se case, there is some issue as to whether pass on to consumers should be a relevant issue. I want to add also, since you're talking about goals, and you mentioned, which I think 99.9% of people will agree with you, that is like one of the main questions in competition law today. I actually think it is a distraction, usually, that usually the goal is to protect the market, keep the market work, keep competition working. It's not necessarily looking to see whether consumers have lost consumer surplus, although some people will say it should be. But this is mostly a distraction when you come to applying the competition law.
And So seems as a distraction, and taking you up on the comment you made that sometimes you would be willing to expand the goals also to adding something else. What are those something else that you refer to?
Here again, you have to be contextual. I think US has it right that it's the market. It's only about the market. It's not about the environment. US, at least until recently, I would say we had a pretty good institutional system in place that could take care of different issues when they come up. If it is South Africa, I totally understand that South Africa wants to have a particular focus on helping and protecting and giving pathways into the competition system for the people that were simply barred by law, unthinkably barred by the majority. Black people were simply not even allowed to participate in the formal economy, and they still are bearing the scars from that. And it would be unthinkable for South Africa to have competition law without focusing also on that. I know in Europe there's a lot of discussion about how and the extent to which environment should come in. And today, I mean, and again, I think it's very contextual, and I follow the debate between the Netherlands, for example, and the EU to the extent they do or don't want to bend competition law to do that. And I just have to respect whichever they choose to do, as long as it is in a rigorous system with institutional protections.
So it's a political question.
Well, it can be a political question. Um, But a question, if you put it that way, you could take it away from the safeguards of being clear about what you want and analyzing it. And I prefer to put it in the context of being clear what you want and analyzing it. So it doesn't end up being political. It's a policy question.
Mhm. Ted, I have a feeling you might disagree with this classification of competition law.
Well, my view is motivated by something I was told many years ago. An antitrust lawyer who became an antitrust professor and then an antitrust enforcer, who spent his early career in a kind of low-level law firm associate position, and he had the opportunity to participate in an old Federal Trade Commission case challenging the practices of certain pharmaceutical companies. This was back in the days when broad spectrum antibiotics had just been invented. So we're basically talking late 1950s, early 1960s. So here's this young, very bright antitrust associate sitting in the hearing room. And he later told the story about how it suddenly occurred to him after listening for a certain time that there apparently was nobody in the hearing room who could describe what the objective of the proceeding was. And therefore, there was no sense even discussing what outcome would best serve the purpose. So once you depart, skipping quickly over the next 50 years, it's my belief is that once you depart from the position that the preservation of competition by means of a competition law or an antitrust law has fundamentally economic objectives, once you depart from that, it quickly decays into complete analytical incoherence. Because as long as you're talking about economics and the total, the size of the pie, the total output that the economy is going to produce, there is generally no way, or certainly no simple and justiciable way, of trading off that objective for some other objective. And just to take a very easy example, in the European Union, there's still a fairly extreme hostility to certain forms of vertical restraints. Territorial restraints of a particular variety are not only condemned, but condemned as blacklisted. In other words, if you put them in a technology license, your whole license is void and you're subject to being fined, which is justified on this notion of, well, let's not have private restraints reconstructed to allow the same types of government restraints that were present in the days of non-Europe. To me, that discussion makes no sense whatsoever, because the private incentives for vertical territorial restraints are based on nothing like the government incentives on internal trade barriers. So how do you trade those off? I don't see anyway. So what the part of what Eleanor said that most concerns me is the notion that this is a distraction. In a system of law, the critical thing is to explain, to have somebody who is on the hook for explaining what his or her decision is. And once you interject these conceptually, kind of orthogonal principles, oh, well, we're going to trade off aggregate output or the productivity of the economy for not imitating government restraints on intra-EU trade, it becomes impossible to nail down the actual reasons for a decision. And I remember having had some considerable experience in the field of regulated industries. We used to, as you know, in the United States, we used to have very comprehensive economic sectoral regulation in a number of very major industries. The easiest one to discuss is probably the railroad industry, or the surface transportation industry, which was very strictly regulated by the Interstate Commerce Commission all the way from 1886 right through 1995, when it was finally abolished by Congress. And so the idea of the ICC was essentially they were required to consider competition. And they looked in many situations where they were required to regulate rates or to consider whether a particular trucking company or a railroad could get a license to carry some product from A to B. What the ICC would say is, well, when we observe trucking companies and railroad companies sharing in the traffic on this route, that's what we mean by competition. But to an antitrust lawyer, that's the opposite of competition. It's the ICC had to maintain rates and entry policies that ensured that a certain structure of competition involving sharing of the traffic between different competitors involved in the two modes was going to be achieved. So to me, many of the, if we want to advantage small businesses in competition in general or in a particular industry, we can have a small business administration. And if Congress wants to shell out X amount of money to subsidize research here or subsidize entrepreneurial effort there, that's a political decision we can debate. But once you start to inject that kind of decision into the question, what is the outcome of this case that will make it most likely that our economic productivity and our economic output will be maximized, you make it an impossible, and you make decision making in that system unaccountable, because there are no principles that can be sensibly debated.
But why would competition be different than in other types of regulators or administrative authorities? So if we know that consumer protection authorities, utility regulators can balance between promoting competitions or at least eliminating market failures and protecting accessibility, price, affordability, stability, why competition authorities are different?
Probably because the question is different. The need for regulation, for example, of consumer disclosures or the use of consumer information is different than antitrust. Antitrust treats the parts of the economy that are considered susceptible to competition. That's a legislative judgment that has to be made. And if you see a market failure, the principles that the United States has been following for a long time, we have this principle that where you have regulation interposed in a competitive industry, the interest in competition prevails unless there is quote unquote plain repugnancy. That phrase comes from an old U.S. antitrust case and basically says the Sherman Act is the Magna Carta of our economy. It provides for competition, and we're not going to preempt it except for specific and very well-found reasons. Congress can enact an exception to the Sherman Act, but private parties can't, as illustrated by our famous professional engineers case, where the industry had all gotten together and decided that price competition was going to be very bad and buildings might fall down. Well, it was pretty easy for the court to say, well, we're not saying we won't automatically reject any justification for an industry-wide standard, an industry-wide principle, but where you say price competition won't work in our industry, you're basically posing such a direct conflict with the fundamental principle of the Sherman Act that we're not going to permit private parties to make that kind of judgment. And then you have a contrasting case not that much later, which was the broadcast music, the BMI ASCAP case. This is the one that essentially said collective licensing of musical works is not a per se, even though the license has one price and all the authors put their creative works into that one license. That's not what the Sherman Act meant when it prohibited competition, and what we meant when we said way back in at the dawn of the Sherman Act that price fixing among competitors is automatically illegal. So,
okay, still staying with the first question, I wanted maybe to ask both of you, based on what you have just highlighted, your kind of normative opinions about the goals of competition law, how much room for indeterminacy, particularly in hard cases, do you allow, given that how interpretable things are and how agnostic we as actors in a typical antitrust proceeding are. And if there is a room for indeterminacy, is it the case that the strongest party with the strongest economic, legal, factual experts would be able to expand this elastic factual and juristic and economic circumstances to the benefits of this party? And if the later, should it be factored in somehow in the institutional setting or in the normative setting? Eleanor.
Could I take my first minute to answer a couple of the propositions that Tad made, and then turn to your question, Elise? Is that legitimate? Okay. So I think that Tad, by your very answers to the first question about goals, showed exactly why we shouldn't spend so much time on this debate about goals, partially because, or maybe exemplary of that, I agree with at least 90% of what you said. I mean, for example, with my own paradigm of saying making markets work, I certainly agree that with the railroads and the truckers shouldn't be sharing their profits. That's not even contestable. On the other hand, there are other particulars with which I disagree. For example, you would not have let the European Union have a market integration goal And this is, to me, unthinkable. And from the beginning of the EU, beginning of the EC, European Community, there were only 6 member states. They had huge barriers among them. The markets that had grown up were within each of the member states. Within each of the member states, there was usually a champion and lots of government intervention, and the markets simply were not cross-border. The market integration goal forced the cross-border community-like market in Europe. Without it, they wouldn't have had it. With it, you're right, they started out being really rigid, and companies doing vertical restraints had to beware. They could not have any provision that restrained trade across member state lines, even for free rider reasons. Eventually, the EU took this on board, and now it is presumptively illegal to have such a restraint, but it can be justified. And this is partly in answer and reflecting on your point, it's mush, you can't deal with it. It's dealt with. So that things have a certain clarity. I do disagree with you that the goal of antitrust is maximum economic output. And here, I would pose this question to you, and it segues right into Ole's question about indeterminacy. To me, that statement of antitrust means that there's probably no action that you could successfully bring against big tech. Is that right? You can almost never show in any of the big tech cases, no matter how restraining they are, for example, of interoperability, that there will be a lessening of output. It's not that output is not the point in almost all of the big tech cases. So I think your paradigm sort of exposes that. But this also leads me to say, yes, I know that's your statement of goals, Tad. And you know my statement of goals. What really matters is what happens, rubber meets the road. So say we're both litigants or even objective observers to write about Google search case. And is it legitimate or not for Google to pay Apple, was it $28 billion a year to have the preferred position of being the default search engine? How we argue that can depend on how we see the goals of antitrust, but we also can predict with a pretty good, more or less range of certainty how a court is going to deal with that question. So this is a question of some indeterminacy. So I'm right in your question now, Oles. There's a lot of indeterminacy. I mean, for example, to take another Google case, which I think you and I, Tad, could easily take positions on the other side of the issue. In Google search and all the Google cases, Google says, I don't have market power. And look, AI is coming. So Google made a really big deal trying to make that argument that it affected definition of markets, it affected effects analysis. The judge in the liability part of Google search said, AI is too far away. I'm not dealing with it. But in the remedy case said, AI is here and we don't have to do any drastic relief. That's very interesting. And so it is a question, sometimes it's a question of what a judge will do in a particular case. Could a different judge have taken the opposite position in that particular case on both the liability point, and the remedy point? And I think actually yes, but I also think that the strongest usually win. And I mean, this segues into a very different question. And again, you could look at it as a Google question. And the judge made this point in his case, I think the liability part of the case, but did not reprimand, did not punish Google. Google slowed everything down. Google made issues of things that were not issues. This happens all the time it puts the defendant at some advantage, even stringing out cases so that when they're finally decided, the market's changed. Or just simply stringing out the case and creating doubt in the judge's mind as to whether, well, maybe really AI is a totally good check on Google's market power and we shouldn't do anything about the exclusionary conduct. So I do think there is a problem of the strength of the dominant firm, where it usually gets, the indeterminacy questions usually get decided in favor of that firm.
I'm ready to to give a little. I'll try to keep this the response part as brief as possible. First, I want to make clear that as to the European Union and the European Commission, it's really fantastic and praiseworthy that institution has grown from the little 6-country EEC and presently 27 countries, and really making tremendous progress in many areas on market integration. And particularly what they've done, if you look, for example, at postal and telecom, all of the member states had dominant PTTs, and by hook and by crook, and the use of economic sense and a great deal of legal imagination, we now have substantially removed those sectors from the grip of public ownership and direct sovereign control. So you now have competitive sectors. Now there's a lot more work to be done. Thinking of the financial sector, which is a current focus, and the sort of, I don't know what the right term is, capital infrastructure. Everybody in Europe is focused on, what is the secret sauce that makes all of our brilliant entrepreneurs and scientists do this wonderful work and then launch a U.S. IPO or whatever. So that's got to do with finance and securities regulation and a lot of things. So my answer there is, you go EU, yes, more integration, more preemption of parochial and sovereign barriers to competition. Absolutely, I'm all for it. We're kind of stuck in the middle of the road right now between the old, country by country approach and the new single market approach. But I'm 100% behind that, and there are many areas where you can cite wonderful work by the EU. But that doesn't mean that I accept in any way Eleanor's very well articulated effort to justify these very strict prohibitions on, and most obviously vertical restraints. But and let me add one other thing. Sometimes I feel a little bit awkward as an American making this point about the EC. The EC and the EU, they have plenty of critics. They don't need me to feel criticized. But in their defense, I have to say that at the time that the fundamental bone structure of the EEC and EU competition rules was being set, what is now Article 101 and 102 and so on, the United States, number one, it was by far the leading antitrust jurisdiction in the world. We had the most experience, we had the most decisions, we had the most active antitrust, but we were at a phase where virtually everything was becoming subject to a per se rule. Schwinn had prohibited all vertical restraints. Seeley and Topko had prohibited all joint venture restraints. all kinds of intellectual property licensing was rendered per se illegal by the so-called 9 no-nos. And then you had cases like Alcoa and United Shoe Machinery Corporation, where there was no bad behavior, no antisocial conduct, no anti-competitive acquisitions, but you could still be liable as a monopolist. And in the case of United Shoe Machinery, you could be broken up essentially because you couldn't prove what the court required in Alcoa, which is that your monopoly power had been thrust upon you. So the point I'm making is that the United States of the 40s, 50s, 60s, and early 70s has to bear some of the responsibility for allowing or encouraging or not preventing the EU from adopting what I think are these terribly restrictive fundamental statutes. Article 101, which is a very broad prohibition and a very stingy exemption standard. And then on the abuse of dominance side, Article 102, all kinds of ideas of unfairness and some really some principles that have been interpreted in a very restrictive, restrictive of business freedom kind of a way. So we're partly responsible. Now on to the direct. I just wanted to make that clear that's the way the world developed. So now on the question of ambiguity, I guess you would say, I think that the system that we have in the United States of having a specific, independent, life tenure, protected decision maker weighing the different arguments is these in terms of its efficacy and getting to sensible decisions is really the gold standard for the world. And that's different from saying that every other country should adopt that same system. I wish they could, but there are probably a lot of reasons why that would be a mistake. But I've been really encouraged. I try to read every new antitrust decision as it comes out, and I am continually amazed at how well, in general, our district courts they honor their obligation to figure out what the law is and to apply the law as it is understood by the Supreme Court and the higher courts. And now but there are situations where it is possible to look at exclusivity, I suppose, is one of those particular areas that Eleanor mentioned in the context of the Google case, and without making any comment on that specific case. There are other cases like the Gilbarco case, which involved gasoline pumps, where you had a company with a very significant market share that used exclusive dealing as restrictions. But I guess my favorite example, and I like to talk about this case a fair amount. You may recall that when Microsoft first started conquering the PC operating system world, there was a very extensive FTC investigation. I think it was about 4 years, and it ended up with kind of a split jury, as I recall. They couldn't agree to issue a complaint, and they couldn't agree to terminate the investigation. And magically, the case ended up in front of Ann Bingaman over at the Antitrust Division at the Department of Justice. Well, it didn't take her long. She looked at the facts, and she found really a single practice that was, to her thinking, obviously damaging to competition, and that was the so-called per processor license. So if you were a PC manufacturer, you'd get a license from Microsoft, that would allow you to install the Windows operating system on all the PCs that you produced. Oh, and incidentally, we don't care what operating system you actually install. We're charging you for every PC you produce because you have the right to install the operating system on that PC. So even if Apple or somebody else comes along and offers a competing operating system, the PC manufacturer is in the position of having to say, well, you know, I've really already paid for this. So unless you can show me the kind of dramatic improvement that would be sufficient to overcome that financial incentive to just use Windows on each of my PCs, then it doesn't make any economic sense for me. And so, fun fact, from the day that Ann Bingaman announced the complaint challenging the per processor license to the day that Microsoft and the Department of Justice signed a consent decree eliminating that contractual provision was almost exactly 1 year. Now, there are two lessons in that. Lesson number one is that exclusivity, yes, exclusivity sometimes can look like a real foul up for competition. And I think that case was correctly disposed of. It wasn't a judicial decision, but I think it should have been prohibited had it gone to a judicial decision. But the second thing is, because it was a very clear attack on a specific and fairly easily understood practice, it was easy to get Microsoft to settle. I was not privy to any of this, of course. I was actually working at the Coca-Cola company at the time, so I had nothing to do with it as a professional other than as an interested reader. But by picking one clear theory and sticking to that point, I think Microsoft realized that if that were challenged at trial, they would lose, and they would be subject to whatever mercy the relevant federal district judge would give them. So now contrast some of the other big company cases. I'll get to digital in 1 second, but even way back in the, for example, in the United Shoe Machinery Corporation case, which was in the early 1950s, decided in the district court in the early 1950s. A whole panoply of different practices, leasing versus sales, all kinds of conditionality and intellectual property license. It was a huge mess. It was a huge case. It was very controversial. It took the judge in the case, Judge Wazansky, hired Carl Kazin, then a PhD, an economics PhD candidate at Harvard, for 2 years to be a law clerk to basically help him figure out what he should do in that case. Eventually, the company was held liable on a whole mixed variety of particular lease and other contractual and licensing provisions, but Wazansky refused to break up the company. But it goes forward. Ultimately, in 1968, the Supreme Court ordered Wazansky to break up the company, and the company promptly disappeared from the face of the earth. I think it was a terrible decision that was the result of extremely broad-based and very vague theories of liability, getting caught up in this monstrous long litigation process. We had a kind of a repeat of that same experience with the U.S. versus IBM case, the one that was filed in 1969. Years and years of discovery and aimless hearings And ultimately, one of the products of the Reagan administration was the stipulation of dismissal without prejudice of that case, because it had become so loaded down with different theories and different arguments, some of which were completely contradictory. So to bring it back to the original question about ambiguity and the power of the big companies to prolong litigation and get their way, I think there's an antidote to that problem. I think the problem is caused by imprecision and in theory, and excessive concern, excessive allegations, a temptation to reach out to try to condemn everything that the alleged monopolist does. And the antidote is the Anne Bingaman approach. Find something that you can prove and go in and get it. And I think if that were the philosophy, this problem of ambiguity and distortions that occur in legal process would be a lot more limited.
I think this takes us really nicely to a different line of question we want to ask about another possible solution. So instead of just narrowing down or the goals or a specific case, perhaps shifting the enforcement model. So my next question, and Eleanor, will start with you. Do you think that the law enforcement model is the ideal for competition law enforcement, particularly when it comes to digital markets? Or should we also shift towards more ex-ante regulatory style of enforcement, for example, as we can see the EU?
Yes, this is a serious question today, especially in digital markets, where a number of cases have been brought on in loads of countries, and they take too long. And issues have to be litigated, relitigated again and again. To just cite once more again, Google says, claims in every single case in every part of the world, I don't have market power. It puts the prosecutor to the proof of proving once again that Google does have market power. And these cases take so long that markets change before relief can be given. Google case itself, Google Shopping in EU took 14 years. Because of that problem, those several problems, EU adopted the Digital Markets Act, and a number of jurisdictions around the world have or are considering whether ex-ante regulation is better or not necessarily better, just a good alternative side by side. So in theory, I think this is absolutely correct, that the companies, these particular handful of what are called gatekeepers, keep doing the same practices again and again because they profit by them still, and there's no good, very clear rule to say you can't do this. So they relitigate it every time, and they keep doing it all the time. And if you can articulate the recurrent abusive practices that you do not want to see happen, and figure out who are these companies that are offending the rules, that's great in theory. So what we're being shown is it's very difficult in practice to apply this ex-ante regulation. It has had some successes, but some great complications in the EU already. I mean, both on the success side and the complication side. And again, I mean, I just think that the companies here who have been qualified in some way as gatekeepers, I know that can be somewhat questionable about who and how to qualify, but certain companies with over $4 trillion market caps, to me, are clearly gatekeepers. I think it is a positive way to go that without this ex-ante regulation, I think the companies will keep doing what they're doing and will evade the law.
Ted, would you agree?
Nope. Europe is not going to regulate its way to enhanced participation in the digital sectors. If you look at the long history of efforts to do similar things in the United States, you had a pattern of antitrust cases intended to prohibit certain conduct and fashion certain decrees that would regulate the structure and the competitive practices of a whole variety of industries. The obvious examples that leap to mind would be the meat packers cases back in the 1920s. I guess it's known as the Armour decrees. Or look at some of the look at the Paramount Pictures decrees, which originated in 1948 and were vacated just 2 years ago, just 2024, I believe. Show me how the behavior, the economic performance, or any other helpful aspect of the motion picture entertainment industry was improved by any of that. It is that kind of detailed intervention in the competitive practices of an industry to me, is so obviously doomed. As a matter of fact, here's one of my favorite illustrative examples. A practice occurred in the Department of Justice of allowing motion picture exhibitors to negotiate, and this is all under the rubric of the decree, of enforcing the Paramount decree. They allowed the exhibitors to get together and to bid jointly for first run rights for new movies. This is a practice known as splitting. Well, when the higher ups at the Department of Justice achieved consciousness that this was going on, this was under Assistant Attorney General John Shenefield and Attorney General Griffin Bell. They said, why are we approving per se illegal monopsony bargaining for motion picture exhibitors? And it required a whole process to get out of that box. So the weaknesses, the mission creep, the political bargaining and so forth that is inherent in close regulation of competitive conduct in key economic sectors it's equally characteristic of administrative sectoral regulation and antitrust enforcement that is trying to do the same thing under the rubric of a consent decree, or in the European case, under the DMA. Show me an industry whose structure or conduct or performance was significantly improved by persistent, detailed regulation of competitive practices. I don't think you can find such an example, although obviously there are particular industries with very significant and special market failures that you can identify, local public utilities and other, you can imagine others. So I'm not saying we should never regulate or Congress should never regulate, but this model of ex ante regulation of competitive practices in these industries offers no optimism whatsoever, in my view.
Okay, can I quickly, being mindful of time, I wanted just to pick up on this point, on your skepticism, Tad, about the possibility of the proactive regulatory steps to build a meaningful alternative to the existing gatekeepers. And I see your kind of apagogical way of criticizing the model, where basically by applying punitive rules, by just constraining the strongest, you cannot create a meaningful alternative unless you have somebody to somehow to benefit from it. Not only business users downstream, not let alone end users, but some newcomers, maybe local players who know their next step, where the actions are probably coordinated. So if this is the case, my question would be to both of you, but again, quickly, how would you do a meaningful, prudent industrial policy? And the US is engaged in many steps in terms of supporting strategically. It's not an antitrust matter, it's probably something more. But is it just for us to say, okay, it's not, we are incompetent here, let us discuss our technical antitrust matters, or we somehow have to communicate with people who make the strategic decisions, making a specific industry superior globally, or contributing, helping? Is it a strategic multi-step approach, or it's spontaneity, or nature and nurture? What's the right recipe? Eleanor, let's start with you.
I'm not sure which question you're asking. Are you asking the big question about industrial policy? About questions that are not antitrust questions? Could you clarify? I'm sorry.
My question is about the role of industrial policy and its collaboration. So, how to build up a successful industry
Oh, okay.
where the narrative of, let's say, Silicon Valley, it's not only about entrepreneurial spirit, it's also about meaningful support by public authorities, being in the right time in the right place. And yet we know many examples how it can be caricaturized and ridiculed and leads to many failures.
Right,
So
right.
there are
So
good and bad industrial policies in a sense.
Oh, right. So I really think you need to know exactly what the particular problem is in which particular country and what particular time. So, or jurisdiction. So EU, for example, or US, for example, EU and the Draghi report, which basically says EU has fallen behind. EU needs to do many, many things. It needs to get rid of overly complex law, too much law. Um, and also may need to take, quote, innovation and scale more seriously in its competition. And if it is to do the latter, and the antitrust law doesn't take care of it, then it is industrial policy bundled into competition law, a kind of stealth way to bundle it in. So my view is that countries and jurisdictions can need industrial policy. It might be in the area of funding R&D, for example, that it is usually a wrong path if they think that an industrial policy override of competition law on mergers, for example, is actually going to make those firms that are merging more competitive in the world. I think it's probably a false narrative. And I think they have to be much more serious and precise about considering if, for example, they are going to make their law, antitrust law, too weak and allow market power to increase, they have to understand what is the result. If it's the US is now going under the banner of America First. We'll do anything we can to make our companies win the race. I think that's very, very wrong industrial policy. Whereas funding research and development, which the United States is getting rid of to a large extent, is a very good way to help win the race and make firms stronger on the merits and make innovation that's good for markets in the world.
Ted?
Yeah, I think Eleanor and I are probably pretty close to agreement in this area.
Right, I'm sorry about that.
That's all right. Well, I'm so glad, Eleanor, that you specifically mentioned funding of generic R&D. I mean, there are some real successes to be identified when the form of government support is encouragement of research on something where the possibility of commercialization is in the way distant future, where you have no idea what products or services or formats are going to have any prospect of success. You combine your resources and try to advance the basic generic technology to the extent you can. And I think there are examples in in telecom and medicine and all kinds of different areas where that's successful. But I share the skepticism about the idea of uh, you know uh, intervening simply by throwing support at existing industries. There's a kind of a middle ground. You may recall that the antitrust constraints on joint R&D were kind of a hot topic in the United States back in the late 60s and 70s, when we were being American companies were being displaced by European and Asian companies in the automobile industry, and in the consumer electronics industry, machine tools industries. One of the products of that concern was a series of legislative enactments: the National Cooperative Research Act, the National Cooperative Research and Production Act, and the standard setting, I can't remember the formal name for it, but a similar act with regard to standards development organizations that basically it did not exempt them from antitrust rules, but it required that their collaboration be judged under a rule of reason standard, and that if you met certain requirements and made certain disclosures, you would be protected from treble damages, even if you were successfully challenged under antitrust. So there's kind of some leakage between the two worlds. The early R&D phase, which often does deserve public support, and the latest stage, which does not. These statutes try to work out a kind of a middle ground.
So I think this is a great place to end on this agreement. We normally end those as in our series in the secret question phase of the talk. So where we invite each one of the speakers to ask the other speaker a question. Eleanor, do you want to go first?
Oh, sure. Thank you. Tad, from the time that I met you, when you came to my house about 50 years ago, to now, I want to ask you about your formation of your ideology, your ideological approach to competition law from then to now. Did you then have the views more or less the same views you have today, encapsulated, as you say, competition law should be about maximizing output and otherwise staying out? Did you have those views then? Did they develop over time? And what have been, if they developed, was there some major influence along the way?
All right, well, it's an interesting question. I'll try not to be too long or boring in my response. The short version of the story is I actually went to law school because I happened to find out that there was such a thing as antitrust law. And it's when I was a senior in college. And I discovered this marvelous joint law and economics program at Stanford Law School, at Stanford University. And so that's where I went. And so from the day I walked into my graduate education, I was focused on antitrust, and I happened to become aware of all the debates about, concentration and profits and the meaning of advertising and so forth. And I read a paper by, what at that time was brand new, written by a recent Harvard PhD, Michael Porter. And he was trying to analyze some of these relationships, and came up with a very clear critique of kind of the conventional structure, conduct, performance paradigm that was dominant in antitrust at that time. And so I in that role, I got exposure to a number of the greats of the law and economics movement. I was a teaching assistant for Harold Demsetz, teaching his course, in which the textbook was Richard Posner's The First Edition of Economic Analysis of Law. And having dealt with that, I had Michael Spence as a professor, and then Bill Baxter as a professor for antitrust and also regulated industries. So I would have to say those were my formative experiences, and I think that I went through an evolution along with Bill Baxter. You know, Bill had been a member of the Neal Commission, the White House report on industrial concentration or antitrust, whatever it was called, and I think he signed on to the basic recommendation of the Neal report, which was to have legislation that would deconcentrate highly concentrated industries. And I think as Bill got more experience and studied more and basically moved away from that position, that is kind of the era in which I formed most of these views. But I've always tried, Eleanor, to remain very open-minded, because I know some of these new industries can have some very tricky aspects, the network effects. And Bill Baxter was actually the person who first successfully analyzed two-sided markets. He wrote a book with a couple of other Stanford professors on electronic funds transfer, and he studied four-party payment systems and became probably the leading expert on the credit card systems. Wrote a fabulous article, which was the basis for an analysis that resolved the old Nabanco Visa case. And so it was really it's a brilliant paper, and that was very heavily influential in my understanding of these network effects type industries. You asked, that's the answer.
Great answer. And Ted, do you have a question for Eleanor?
Well, Eleanor, what I'd like to ask you is, I mean, you are the world's leading antitrust globetrotter, and I wonder, in all your experience with so many jurisdictions and the whole range, from Europe and South Africa, and I assume there are very few antitrust agencies where you haven't visited and spoken. I'd like to ask you what you think about the view that the availability of an independent judiciary, whether or not your approach is an ex post enforcement model or an ex ante regulatory model, what do you think there's any consistent message from your experience about the value of an independent judiciary?
So thank you. Yes, there's a problem in theory and in fact of what is possible. An independent judiciary is invaluable, and I agree with everything you have said about the value of it. It is very hard for many smaller, younger competition jurisdictions to have such an independent judiciary, and even to get cases into the courts. And there's so few cases that come up into the courts that it's also very hard to have expertise on the court. So they have to do what they can and try to preserve as good an institutional system without conflicts of interest to the extent they can. They realize the challenge, and some are doing it and able to do it better than others. And I feel, though, despite the fact that that's a really difficult challenge, and moving away from that particular challenge, I feel that there are a number of developing and emerging economies who are very dedicated to doing the job, to doing it right. Within the competition agency itself, there's an enormous amount of non-corruption in a very corrupt society, and therefore these sort of hero people who are trying to lead their agency on the right path.
Eleanor Fox, Ted Lipsky, thank you very much for sharing your great ideas with all of us.
Really
Thank
good,
you.
great questions.